looking into the Constitution Act of 1867, Article 11, it states, "There shall be a council to aid and advise in the government of Canada, to be styled, designated, or termed the Queen's Privy Council for Canada, and the persons who are to be members of that council shall be from time to time chosen and summoned by the Governor General." Constitution Act of Canada, 1867, Article 13. The provisions of this act, referring to the Governor General in council, shall be construed or taken as referring to the Governor General acting by and with the advice of the Queen's Privy Council for Canada. Well, if the Governor General is acting by the Queen's Privy Council, then it's the Queen's Privy Council who is controlling the Governor General. When you're acting by and with the advice of someone, then you're being controlled by the one that is giving you advice. You're being controlled by the one that you are acting by. So here we are seeing that it's actually the Queen's Privy Council who has the authority. Now keep that in mind as you watch the rest of this video. We're looking into the Financial Administration Act of Canada. And as it reads here, an act to provide for the financial administration of the Government of Canada, the establishment and maintenance of the accounts of Canada, and the control of Crown corporations. Treasury Board, Article 5.1. There is hereby established a committee of who? Of the Queen's Privy Council for Canada, called the Treasury Board, over which the President of the Treasury Board, appointed by commission under the Great Seal, shall preside. All right, so this committee, right, that's designated or termed the Treasury Board, right? This committee works on behalf of the Queen's Privy Council. This committee is directly for the Queen's Privy Council. Now in Article subsection 2, it says the Treasury Board shall, in addition to the President of the Treasury Board, consist of the Minister, which is the Minister of Finance, and 4 other members of the Queen's Privy Council for Canada, to be nominated from time to time by the Governor in Council, the Governor General. So here we're seeing that it's the Governor General, right, that appoints the Queen's Privy Council members into the Treasury Board. But when we go back into the Constitution Act, what we just looked at, right, it says it's the Queen's Privy Council that tells the Governor in Council what he must do. So what we need to understand here is that the Treasury Board that's in operation in Canada under the Financial Administration Act, it's a committee of the Queen's Privy Council. There's 4 members of her council in this board. There's the President of the Treasury Board and the Minister of Finance. So everyone who's on this committee, right, is operating on behalf and in the name of Her Majesty and for Her Majesty's benefit, not for our benefit. The Financial Administration Act, Article 23, where it says tax, includes any tax, impost, duty, or toll payable to Her Majesty, imposed or authorized to be imposed by an act of Parliament. All right, so any taxation that is imposed by an act of Parliament. Well, they say the income tax enactment, right, is an act of Parliament, and it's imposing a duty to pay an income tax. So here, in the Financial Administration enactment, when you use the word tax, it includes income tax. Remember, in the Canada Revenue Agency enactment, it says the agency for all purposes is an agent of Her Majesty in right of Canada. So the CRA is operating on behalf of Her Majesty as an agent of Her Majesty and is collecting taxation on behalf of or for Her Majesty. Financial Administration Act, remission of taxes and penalties. The Governor in Council may, on the recommendation of the appropriate minister, remit any tax or penalty, including any interest paid or payable thereon, where the Governor in Council considers that the collection of the tax or the enforcement of the penalty is unreasonable or unjust, or that it is otherwise in the public interest to remit the tax or penalty. Now notice that it's the governor and council who has the ability to remit or cause remission of the tax and the penalty. As the governor and council, the governor general, he represents the queen, right? He has the authority of the queen, and he's under the same obligations of the queen. Now, the queen is subjected to the international covenants, and Canada is subjected to the international covenants. And the governor and council, the operations he creates and the things he can do or not do are also subjected to the international covenants. And here it's saying that this governor and council can remit tax or the penalty if it's unjust or unreasonable. Well, if you hit that office up, right, with a notification and a claim that the taxation that they're placing upon you is unreasonable or unjust. Why? Because it goes against fundamental human rights and freedoms. Because it goes against the international covenants. And the obligation that you've placed upon me is unreasonable. And the obligation that you placed upon me is actually unjust in law. And that's why we see here that the governor and council, right, he retains that power. The statutory instrument, the statutory enactment, has granted the governor and council the power to make remissions or remit any tax that is owed or any penalty that is owed. Now, why would the legislator give this power to the governor general? Or why would the legislator provide this operation of law within the Financial Administration Act? Well, it's because there's an obligation upon them, right? There's an obligation upon them to allow you to exercise your fundamental natural right, your human right, as found in the International Covenant. And if the CRA is coming against you, well, there's somewhere higher you can go. So we are learning here that there are two offices that must receive a communication from us. And it says the appropriate minister, that would be the Minister of Finance, and the governor and council. So my notice, my letter, would be sent out to the Minister of Finance. And I would CC a copy to the governor and council. And in addition, when I send my copy to the governor and council, I would expand more on the situation, on what's going on. I'm going to expound and explain the fact that I have a natural right, a human right that's found in the international covenants. And I don't have an obligation to contribute on the principle based on mutual benefit. And that I've been rendered a certain class of person, a prescribed person within these enactments. And that I've been taxed and I've had penalties applied to me in this situation. You're going to have to go deeper than that. But you understand the argument. You understand the position you're going to send to them. Pursuant to this section may be total or partial, or conditional or unconditional, and may be granted A. Before, after, or pending any suit or proceeding for the recovery of tax, penalty, or other debt in respect of which the remission is granted. So, if you're taken to tax court, right, and they've already judged against you, well, that doesn't stop you from contacting them and asking them for the remission. Well, more precisely, you wouldn't be asking them, right? You'd be telling them. You'd be commanding them. And here it says, before any suit has started. Well, you're having trouble with the CRA over an assessment. Well, you have the ability to contact the Minister of Finance and the Governor and Council. Or, if you're in the middle of the suit, if you're in the middle of tax court, this operation of law continues to work. And then it says a remission can be granted before or after any payment of tax, penalty, or other debt has been made or enforced by process or execution. So even after you've paid, even after they've taken your property, a remission can be granted to you. And if they grant you your remission, well then you're restored. What you lost has to be returned to you. Now what's going on here? Why is this operation here? Again, I'll profess to you that this operation is here because they have to respect fundamental human rights. They have to respect our natural rights. And when push comes to shove, right, we're seeing here that a remission of the obligation to taxation can be obtained because it's unjust against you. Why? Well, Her Majesty is acting unjust against you. She's enforcing laws against you that are limiting and abridging your fundamental right and freedom. And remember, in the International Covenant, it clearly states that they have to give effect to your rights, either through the Constitution Act, through domestic law, or other measures. And what you're witnessing here in this video is them giving effect to your rights through domestic law. We understand that the CRA is in operation. We understand that the Income Tax Act they claim is in operation. And they use those enactments to cause us or force us to contribute. But that doesn't negate their responsibility. That doesn't remove our fundamental right, our natural right. They're inalienable. They're absolute. So therefore, we see the operation of law that says, well, a remission can be taken place. A remission can be granted. And how do we get that remission? Well, your argument's got to be correct. Your argument's got to be brought forth through the principles of justice. Those fundamental principles. If you can articulate and express them and bring them forth and show the limitation that Her Majesty has placed against you, then the governor and council, as her representative, and the minister, as her representative, right? Part of the Privy Council, they have the obligation to remit what they've done to you. That's why it's in the law. That's why it's present. Look at section C. With respect to a tax or other debt, in any particular case or class of cases, and before the liability thereof arises. Huh? What are you saying? What's the statutory power saying? That before the liability arises, remission can take place. Well, why would they do that? And who would they be looking out for to do that? Well, I guess someone who's exercising their fundamental right and freedom. I guess someone who's contacted them and told them, I'm not putting up with this anymore. And you're not going to do this to me anymore. And if you create a liability against me, then I'm going to come against you. Well then, the statutory power, right, gives them the ability to make sure and to be careful that no liability is created, that no liability arises. Now, form of remission. A remission pursuant to this section may be granted by forbearing to institute a suit or proceeding for the recovery of the tax, penalty, or other debt in respect of which the remission is granted. So, if they grant you a remission, right, it means the CRA, it means the agent of Her Majesty has been put on a leash and is not allowed to go against you and to bring you to the tax court and to institute a suit or a proceeding against you for the recovery of that tax. It says a remission also can be granted by delaying, staying, or discontinuing any suit or proceeding already instituted. So, you're in tax court. They've got you into the court. Well, you can do this operation of law, right? And the remission, when it's granted, it stops and discontinues the suit that they're trying to do against you. Or by forbearing to enforce, staying, or abandoning any execution or process on any judgment. So what's that saying? Okay, you got a notice of assessment, right? They say you owe them $1 million. They say you owe them $1.8 million, $5 million, $200,000, whatever it may be. And they're saying that if you don't pay this assessment, we're going to come after you. Well, when you get a remission and it's granted, right? Well, then that assessment, the notice to pay is canceled. The obligation to pay is canceled. It's abandoned. The process is abandoned. Subsection E. By repaying any sum of money paid to or recovered by the Receiver General for the tax, penalty, or other debt. So if a remission is granted, then the money that you paid to, the money that you gave to the Receiver General for the tax is recovered. And that includes personal property. Talking about the house. If they came and sold your house out from under you and kicked you out. Like I said, this evil working law, this evil created law, if it did that to you, well, when you're granted your remission, right? Well, they have to recover what they did to you. And here it says if you paid any sum of money recovered by the Receiver General for tax, well, it has to be given back to you. Now, how long have you been paying taxes? And that's why I say to those that since the covenant was ratified, it put the obligation on Her Majesty. And ever since then, ever since they signed that covenant and ratified it, well, if you've been paying any sum of money to the Receiver General for tax, well, you could have something to say about it, don't you? I'm going to stop here because I know sometimes it's hard to process this information and to absorb what's being said and being brought forth. It's funny how when we look into the Financial Administration Act, right, they titled this whole operation of law remission, and remission is granted, and then you walk away from the unjust actions that they've done to you. But let me ask you in truth, who's receiving the remission here? Whose sins are being remitted? Whose wrongdoing is being remitted? Whose evil actions are being remitted? Not mine. Not mine. The Queen's. Her representatives. By doing this, right, they're finding their remission. She's finding her remission. Why? Oh, only God knows, right? A mental note to all those who have listened to this video. Every time you heard me say the Queen, I was really saying the King. You misheard me.